What do you do when the defense turns around and says, you know what, you have a good case, we're willing to negotiate, but we're going to wait and see what the judge does with our summary motion first? What do you do in that instance? You want to know what you do? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. Your doctor denies all of your allegations and says, I'll see you at trial. Fine, so we go through the entire litigation process. That takes about 2 or 3 years in which to get to the point where you advise the court that you are now ready for trial. We actually have to file a document called a note of issue with the court, which basically alerts them to the fact that we have finished, we have completed all of the discovery necessary before we get to trial. So what happens next? What happens next is that the defense sometimes comes to us and says, okay, I know that your case is technically ready for trial. We are interested in trying to negotiate your case. However, we want one last shot at the apple to try and get your case dismissed and thrown out before we ever even offer a dime. Now, what's all that about? It's the defense's last opportunity to try and get your case dismissed before they start negotiating. Once discovery is complete and we have finished all the depositions, we have completed exchanging all the medical records and documents necessary, and the defense has done the same. Now the defense has an opportunity, if the situation arises, to ask the court to throw your case out. It's called a motion for summary judgment. And all that is a formal written request to the court that says, hey, Judge, Oginski's client doesn't have the requisite proof. He doesn't have a valid case, and therefore we want you to throw the case out. In that instance, now we have to put in papers to oppose that request. And it's basically having a trial, except it's being done on paper and it's being done before the actual trial. Then the judge will take a number of months in which to actually reach a decision. If the judge agrees with the defense that there are legal issues to be resolved and the judge resolves them in favor of the defense, there is the good possibility that he will throw your case out and your case will never get to trial and your case is over before the defense actually offers a single dollar. If, on the other hand, the judge says, look, I find that there are significant questions of fact on material issues in this case, which means the jury has to resolve these questions of fact. Who is more likely right than wrong? The judge is not the one to do that. Even though this is a trial that's happening on paper, and now all the evidence is submitted on paper, documents and photographs and pretrial testimony is submitted to the judge on paper, the judge does not actually decide who's entitled to a verdict. Instead, the judge, during this request to throw your case out, is going to decide one and only one thing: whether there are questions of fact for the jury to decide. If there are, the judge will deny the defense's request to throw your case out. Okay, if that happens, what happens next in terms of negotiation? Well, now we reach the point where the defense no longer has the opportunity to get your case thrown out before trial. And there is the possibility that the defense will now want to negotiate or engage in settlement discussions in an attempt to try and resolve your case without the need to go to trial. So why do I share this quick information with you? I share it with you because it's a gorgeous day today and I had a few minutes while my wife is out on the beach picking seashells to share this useful information, and hopefully it's eye-opening and gives you a clear understanding of exactly what happens in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. You know, I recognize you're likely watching this video because you want to see the beautiful scenery. No, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.